Hey, good morning.
Morning, Judge.
Good morning, Mr. Fedor. How are you?
Good, thank you.
What are you here on?
Durante Hickman.
Okay. Haven't seen this Howard yet.
Okay. All right, sounds good.
That's the prosecution.
Morning, everybody. Hey, good morning. How are you? Good morning, Mr. Fedor.
I get the 9 o'clock exam off to
Okay, is fire here yet?
No.
Okay, I'm off mute.
Okay, now.
Good morning, Mr. Chastain.
Oh, now I can. Yes, good morning. Bye.
Good morning.
Morning, Judge.
Morning. How you doing, Jess?
Good, how about you?
All right. Yes.
Case number 2405-557101 for the state of Michigan versus Philip Davis. Defendant is charged in count 1, homicide, murder, second degree. Count 2, weapons, fire, possession by felon. Count 3, weapons carrying concealed. Counts 4, 5, weapons, felony, firearm. Defendant has a habitual offender for the offense notice.
Appearances for the record, please. Mr. Cassidy, your appearance, please. Mr. Cassidy. Your appearance for the record, please. This guy, man, too.
Yeah.
Your appearance, please.
Yeah, I can't hear him. It's not working again. I can't believe it. I had him for a second.
You want to come on mine?
Yeah, okay, I'll come on yours. God. Are you at that court too?
Hi, Your Honor.
Yes.
Mr. Cassidy was having some issues with his audio, so he's gonna come on here.
Okay.
Okay.
Thank you.
Earbuds. I can't, for some reason, computer audio.
Isn't that amazing?
Your appearance for the record, sir.
Put your appearance on, Mr. Cassidy.
Hello,
Can I have your appearance, please?
Paul Cassidy on behalf of the people.
May I please court Your Honor, Tyrone Baker at P number 62647, appearing on behalf of Mr. Philip Daniels.
Okay, why are you guys here now? This matter is scheduled for 11 o'clock today, for example.
That is correct, Your Honor. We've had some issues with regards to the discovery. Me and Mr. Cassidy have been speaking for the last 2 days, trying to resolve that. I now have what is a very voluminous package, Your Honor, and it's trying to process through our system here at NDS. But this started a couple of days ago. Mr. Cassidy had reached out to me about a possible stipulation. I had reached out to him regarding the fact that I still had not received discovery. He sent it, but it would not process. We've been going back and forth, Your Honor. And yesterday I contacted him and said, Mr. Cassidy, I have no choice but to ask the court for an adjournment. And that is why we're here today, to ask the court for an adjournment of the exam. I have not had a chance to review these materials. It would not process through. There were issues with downloading, et cetera, Your Honor. I can go back over the history of when the requests were made, et cetera, but I'm not trying to point any fingers. I just, at this time, Your Honor, it's just a situation where we could, I haven't had a chance to review the discovery at all. I do have it now. It's being processed through the system. I was told it should have been completed sometime in the middle of the night.
So, Mr. Bickert.
It's approximately 12 gigabytes, Your Honor.
Mr. Bickert, you know me for a long time. I think you know me well, know that I had an issue when you asked for an adjournment on the day of the exam.
I understood, Your Honor. That's why I was trying to resolve this ahead of time, Your Honor. I apologize. I did contact the court yesterday. I did send an email related order, but it was just late yesterday.
The only day that I can accommodate you would be Tuesday, the 27th, any time of day.
That's next Tuesday, Your Honor?
Yes, sir.
That works. I believe Mr. Cassidy and I had indicated anytime after 10 a.m., I believe, on Tuesday. Is that correct, Mr. Cassidy?
Anytime on Tuesday is fine with me.
That's fine with me too, Your Honor.
You say after 10 a.m.?
Oh, no, I can do any time really on Tuesday.
So can I.
Let's do the 27th at 10 o'clock.
All right.
Fine with me, Your Honor.
All right. Fine will be continued.
Thank you. Thanks. There's something wrong with that computer. Sometimes the volume just won't.
Still got hot mic.
Oh, it's hot. Good morning, Ms. Howe.
Good morning, Judge.
You are here on
Mr. Hickman? Yes.
Okay. Do we have a competency report back?
Yeah, I believe so. Yes, we do, because I got the email. They found no competent.
Okay. We're ready on here.
Calling case number 2305940 for the state of Michigan versus defendant number 1, Loretta Hick. Defendant is charged in counts 1 and 2. Counts 1 and 2, homicide, murder, first degree premeditated. Count 4, weapons, felony, firearm. 6, weapons, firearm, possession by felon. Defendant has a habitual offender or defense notice.
Appearances for the record, please. Mr. Fedora.
Good morning.
Your appearance, Mr. Fedora.
Good morning again, Judge. Mark Fedoruk for the people, P76177.
And good morning, Tiffany on behalf of Mr. Hickman, P79667.
Okay, what's today's date and time set for a competency hearing? Ms. Howell tells me that we do have a report back finding the defendant competent to stand trial. You stipulate to those findings, Ms. Howell?
Yes, Judge.
How about you, Mr. Fedora?
We do stipulate, Your Honor.
Okay, what's your pleasure, Ms. Howell?
Your Honor, we're demanding an exam.
Court will continue to plead not guilty. We'll set this matter for preliminary examination. How is March 14th at 10 o'clock?
Judge, I'm starting a trial on the 12th. So I anticipate that we'll still be in trial on the 14th.
That was the other day I had for you, maybe the 12th at 30, but you can't do that, right?
No, Judge.
March 19th?
I'm scheduled to start a trial that on the 18th, but I do think that that's going to resolve. So we can schedule it for now, and I can let the court know if it doesn't resolve and if it's going to go. But I am pretty confident it's going to resolve itself.
And Your Honor, can we just have a time of 11:30 or later, just because I have a sentencing that morning?
Okay, March 19th at 11:30.
Thank you, Judge.
All right, thank you.
I'll be continued. Thank you.
Have a good day, Judge.
Thanks, you too.
And Ms. Howell.
Thank you. Have a good day, Judge.
You too, Mr. Howard. Mr. Nomo, you here on Mr. Cripps' exam?
Yes, sir.
Are you ready?
No, I need my one witness, but he's on his way.
Okay.
One officer.
All right.
Well, yeah, because it's a custody order, so he got.
Ms. Schlusser,
Yes, good morning, Your Honor.
good morning. What can I do for you?
So I am here on Dominique Williams.
Okay. I think we're ready on time. Ms. Davidoff.
Yes, Your Honor.
What are you here on?
I am here on Beverly Jordan. I think the attorney is Bates.
Okay. So I need an APA here for Ms. Blue. Okay, we're just waiting on an attorney for you, Ms. Schlusser.
Okay, thank you.
And we reached out to Ms. Bates, Ms. Davidoff.
I'm sorry, did you want me to reach out?
We just did.
Oh, okay. I'll sit here. I'm okay.
People are, is your witness here yet?
No, Your Honor, not yet. But I'm gonna stand in for, Williams.
All right, okay. Okay, we're voting on Ms. Williams.
Yes. He's up.
Always.
He's ready.
Yes.
Call in case number 2405541201, people of the state of Michigan versus Dominic Williams. Defendant is charged in count one, operating while intoxicated, causing death.
Appearances for the record, please.
Good morning, Your Honor. Sarah Bell, staff of People, PA 4189, standing in for the attorney of record, Steve Lockpiller.
Good morning, Your Honor. Deborah Schlussel, P56420, on behalf of the defendant, Ms. Dominique Williams, who is on the Zoom call. Ms. Williams, please state your name.
Dominique Williams.
All right, what's your pleasure, Ms. Schusser?
So, Your Honor, I do believe that I have the discovery, but excuse me, my client just got out of jail, and so I need time to go over it with her. Is it possible to set an exam for the morning of the 1st?
No, that's not my homicide.
That's a week from tomorrow.
I'm sorry.
A week from tomorrow, it will be within the 21 days.
I said that's not my homicide day. I do homicides on Tuesdays.
Oh, okay. Can you do the morning of the 8th?
I'm not going to be here then. I can do the 12th. Sorry, yeah, 12th or the 14th.
The 14th works, Your Honor.
That works for the people, Your Honor.
What time is good for you? 10 o'clock?
Yes, Your Honor.
People?
Yes, Your Honor, that works for people.
All right.
Your Honor, just in case, can we do 10:30?
Okay, March 14th at 10:30.
All right, Your Honor, we had some questions or some issues that we wanted to address with the court. And forgive me, I have a frog in my throat. Your Honor, my client was ordered to test.
She was ordered to do what? I can't hear you all of a sudden.
Oh, can you hear me now?
Yes.
Okay. She was ordered to test for this case for bond and as one of her bond conditions. She is already testing for family court. So it's a double testing, and we were wondering if that could be removed and if her results from family court could be reported to the court.
Your Honor, Your Honor, can we be provided documentation of this and then address this at the exam?
We would be happy to bring that, Your Honor.
Okay.
We have a couple of other issues. Number two, Your Honor, my client was put under house arrest, except, I think, to go to medical appointments and court. And Your Honor, you know what? I just realized something that might obviate the moving of the exam. So I'll mention that first. Ms. Williams has a gallbladder removal surgery scheduled. I believe it's for next week, correct, Ms. Williams?
Yes, the 29th.
All right. And how long did the doctor expect that you would be out of commission and unable to come to court?
Maybe a couple of weeks, maybe about 2 weeks. I never had the surgery done, so I asked to, I'm not really sure, but he said it's gonna probably take some time because I'm gonna be in pain. It's abdominal surgery.
Your Honor, just to be on the safe side, is it possible to move it to the 28th?
No.
And we would waive the. I'm sorry, what?
I said, no, I don't want to go any further than the 14th.
Okay. All right, Your Honor, if she's in pain and can't come to court, I'll know the day before. Could I contact the court at that time? I mean, it's major surgery.
Maybe she can zoom in.
All right.
I would just ask that documentation be provided for that as well, if she's not able to attend the exam by a doctor. No.
I have no problem with providing that, Your Honor. Number 3, Your Honor. So her condition of bond is that one of her conditions is that she cannot, she's under house arrest and she can only leave the house for medical appointments and court. And Your Honor, I would ask that this be adjusted because for 2 reasons. Number 1, she has partial custody and joint custody and visitation time with her children, and she has to pick them up and take them to school and take them on certain weekends and certain dates. And she's unable to do that right now with the current bond conditions. And we would ask that since there is a family court order in place for that, that her bond be adjusted to allow her to go pick up the kids and to well, she isn't right now, but she's allowed to. She has a valid license. That was the next thing I was going to ask you.
If she's not driving, how's she picking the kids up?
So she hasn't been able to, Your Honor. She just got out of jail and she hasn't done anything because of the bond conditions. The bond conditions were no driving and house arrest and so on. So we're asking that she be allowed to drive. She has a valid license. The state of no driving.
No driving.
Okay. What about, is she allowed to go out of the house with another person driving to pick up the kids?
What kind of sense does that make?
I guess she'll have to have someone else pick them up then.
Okay.
Your Honor, the other thing was she's on disability. She was earning extra income doing Shipt. And so
What?
Shipt, SHIPT, it's one of those shopping services.
Doesn't that driving too?
Yes.
No.
All right. Could she leave the house to go with someone else to do it?
No.
Okay. All right. Ms. Williams, is that everything we had discussed?
That, I believe that's all. I have also attended weekly AA meetings through family court for the past 2 years.
Is that court ordered?
Yes, both the screening tests were for 2 years, as well as the AA meeting, the weekly AA meetings.
In defense counsel, could you send me documentation of that?
Sure. I could send you all of that. Can I ask you, may I have your email address, please?
So I'm standing in for Steve Lockfiler, so I'll get with him and I'll let him know to reach out to you and ask for that.
Okay. All right. Thank you.
And then, Your Honor, people would have no objection once that documentation is provided.
Okay. All right. Thank you, ladies.
Thank you, Your Honor.
All right, are we ready on Robertson now?
Yes, Your Honor.
Yes, Your Honor.
Calling case 2357316, people of the state of Michigan versus defendant number 1, Donald Will Robertson. Defendant is charged in count 1, reckless driving causing death. Defendant has a habitual offender second offense notice. Appearances for the record, please.
Good morning, Your Honor. Sarah Benoma on behalf of the people, Pete 4189.
And good morning, Judge David Cripps, P 34972, appearing on behalf of my client, Donald Robertson, who's standing to my left. Tell the judge your name, sir.
Donald Miguel Robertson.
Okay. There's a date time set for preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Defense is ready. We make a motion to sequester witnesses.
And I would ask for an exception.
Okay, go ahead.
And Your Honor, I would ask for an exception to the officer in charge who sits to my right, Detective Anthony Besso, who will be my one and only witness.
No, Your Honor. All right. Ladies and gentlemen out there in YouTube land, if you are a witness or potential witness, I'm ordering you to log off at this time. Have any preliminary matters before you call your witness?
Yes, Your Honor, great. The first one is people would move to omit People's Exhibit 1, which is the postmortem report under MCL 76611BG. We have a stipulation between the parties for the omittance of the People's Exhibit 1 for identification purposes. The deceased located at the scene is Sarah Nicole Robinson. That was the body that was examined for exam purposes only.
I have no objection to omission of proposed one, but for the limited purpose of the cause of matter, not for any hearsay that's contained or any other issue.
Understood.
Your Honor, may I publish?
Yes.
Your Honor, the pertinent portions of this exhibit read that it's entitled "The Postmortem Report from the Office of the Wayne County Medical Examiner."
Radioactivity going on here.
Yeah, okay. People's Exhibit 1 is entitled "The Postmortem Report from the Office of the Wayne County Medical Examiner." It certifies that Dr. Teresa Nguyen, the spelling is Nguyen, Assistant Medical Examiner, performed a postmortem examination on the body of Sarah Nicole Robinson at the Wayne County Medical Examiner's Office on November 25th, 2022, with the ME case number of 22-16319. In the summary and opinion portion of this document, it states it's my opinion that death was caused by multiple injuries. The manner of death is accident, and this report is signed by the medical examiner. My next preliminary matter, Your Honor, is I provided notice to defense counsel that I'll be amending the information to add count 4 for the charge of operating license suspended, revoked, denied, causing death. That's MCL 2579044.
On my notes.
Okay.
And with that, Your Honor, people would move to amend People's Exhibit 2, which is a certified copy of the defendant's driving record pursuant to MCL 76611B, Section B, for exam purposes only.
Your Honor, a copy has been provided to me. I reviewed it before calling of the examination, and for exam purposes only, I have no objection to its submission.
Admit it?
Your Honor, may I publish?
Yes.
And Your Honor, for People's Exhibit 2, on page 2, the defendant's name is listed as Donald McCall Robinson. Turning to page 21 of the exhibit, which is tabbed out. On the second section on that page, it states type, conviction, plea. The posted date is October 19th of 2022. The section below that, it says type, additional action, suspended from November 4th, 2022 through December 3rd, 2022. Not valid from December 4th, 2022 until the requirements have been met. And with that, Your Honor, people are ready to call the first witness.
Please do.
Your Honor, this time people call Detective Anthony Costa.
Sir, please give your spelling and spelling to the court reporter. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you, sir. Please have a seat in the response. You may begin when you're ready.
Thank you, Your Honor. Can you please restate your name again for the record?
Yes, that is Detective Anthony Festo of Detroit Police Department.
And how long have you worked at the Detroit Police Department?
12 years.
And were you employed in that capacity on November 25th of 2022?
Yes, I was.
And on that date, what was your title or your role in this case?
I was the OIC.
Okay. And were you employed, I'm sorry, did your duties take you to Grand River Avenue in North Lawn Street?
Yes.
Is that within Detroit County of Wayne?
Yes, it is.
And can you describe how many lanes are on West Grand River?
Grand River is 3 lanes east and 3 lanes west of the center.
Is there a street light at that intersection right there at Grand River and North Lawn?
By street light, you mean?
Like a traffic light?
Traffic light, no.
And what brought you to that location?
I was recalled there for a 2-vehicle fatal crash.
And what kind of vehicles were there on the scene when you made that?
There was a gray Chevy Malibu and a black Chevy Tahoe.
And where was the Tahoe located?
The Tahoe was still on Grand River facing east toward downtown, and Malibu was up the side.
Okay. Was there damage to these vehicles?
Yes.
I started with the Tahoe. Where was the damage at?
The damage was all front end damage, mainly on the front passenger side.
And what about the Malibu?
Heavy front end damage.
Were there any individuals outside the vehicle of the Malibu?
Again, Your Honor, at this point in time, I'm asking that he can only testify as to what he saw when he arrived at the scene.
I thought that's what he was testifying.
And it wasn't clear to me.
Well, when I asked him, did your duties take you out of your Grand River Avenue, why did you need that location? That's it.
You may proceed.
Was there a deceased located on the scene?
Yes, there was.
Okay. And did you speak to the driver?
Judge has to be,
Doesn't suggest an answer.
it does suggest an answer that someone's right.
I said that it didn't overrule. Proceed.
Did you speak to the driver of the Malibu?
Yes.
Okay. Do you see that individual in court today?
Again, I reject it, Your Honor. There's no showing that my client was the driver.
Well, we're about to show it because I just asked, did you speak to the driver of the vehicle? He said,
How do you know
yes.
the person was the driver?
Give a statement
From who?
from the driver.
From the person.
Proceedings.
Okay.
Oh, sorry. This one here? Oh, sorry. Yes, okay.
I'm going to be objecting to the admissibility of somebody who's at the hospital getting medical.
Well, for now, can I rephrase the question?
Go ahead.
Okay. Did you speak to an individual that was located in the vehicle of the Malibu?
Yes.
Okay. Do you see that individual in court today?
Yes.
Okay. Can you please point to that individual and state something there where?
Black male with pretty and bibs or
Your Honor, may the record reflect the identification of the defendant?
So noted.
Okay. When you spoke to this individual, did he tell you if anybody else was located in that vehicle with him?
Yeah.
How many people were located in that vehicle?
Just
Okay. And where was his wife located at in that vehicle?
front passenger seat.
Okay. Did he state where he was located at in the vehicle?
He stayed with the driver.
Okay. And who was in the back seat?
think there was 2 kids in the backseat.
Okay. Did he make a statement about what, where he was traveling?
Judge, this is police interrogation without Miranda, so I would object to the statement.
And I can ask follow-up questions regarding that. At this time,
I'll sustain that objection for now.
when you spoke to the defendant, were you in street clothes or were you in police uniform?
Basically, what I'm wearing now, but maybe a bedroom in
Okay, and what you're wearing now, can you describe that?
it, just like a polo shirt. I'm not sure if I was wearing jeans or slacks or khakis that night.
The record should reflect what he's wearing now, and clearly indicates he's a Detroit police officer wearing a logo.
And who else was in the room with you?
Don't remember, I think I was there by myself, but
Did you have an opportunity to, watch your interrogation? Not interrogation, your interview?
not in the past year.
If you watch a portion of it with that refresh your recollection, Your Honor, may I approach?
Okay.
As much as it as you need to.
Doesn't have to be long, but okay.
Your Honor, may I approach?
Yes.
It's a refresher. Does that refresh your memory?
Yes, I mean, I didn't watch the whole thing, it's 8 minutes, but
I can't hear it there.
I didn't watch the whole thing, it's 8 minutes, but
It's at the microphone, and you're not, basically, you're not speaking directly.
okay.
Does watching this, conversation with the defendant, this video, does that fairly and accurately depict your conversation with the defendant?
Yes.
Committee in question?
Yes.
Okay, Your Honor, at this time, people would move to omit People's Exhibit 5.
I'm objecting, Your Honor, to that. In admission of his statement, he's at the hospital under medication. I don't think it would be a voluntary statement.
He said it was under medication. It was under medication.
I guess I could. Detective, you said you went to the hospital?
Yes.
Which hospital?
That was Henry Ford Hospital.
And what was your intention in going there?
To take a statement from both drivers.
Okay, and so they were suspects in the fatal crash?
I don't know if I say suspects at the time, but we had to go statement from both drivers.
Well, you were a police officer going to interrogate them regarding what you thought to be a fatal crash, is that correct?
It was just like an interview. It was, yeah, they were not in custody at all.
Well, I understand that, but your intention was to interview my client who you suspected to be the driver of the vehicle, one of the vehicles, is that correct?
Yes.
All right. And so when you went to the hospital, where did you find my client?
He was in a room or a hospital bed.
He's in a hospital bed, in a
Yes.
hospital, is that correct?
Yes.
Receiving medical treatment.
Yes.
Your Honor, I would object to speculating
Right.
if he knows if he's receiving medical treatment.
Did you make any inquiry with the nursing staff as to whether my client had been administered any medication?
I don't remember.
So you don't know whether he was under the influence of any pain medication or any other type of medication at the time he went into work?
That I'm not sure.
Did you, when you came into the room, did you consider my client the driver of one of the vehicles?
I don't remember honestly. It's just a statement to figure out what happened.
All right, so you were trying to figure out who the driver of the vehicles were by interviewing people.
Yes.
So prior to going to the hospital, you weren't sure who the driver of the Malibu or the top was.
I was just advised by the first responders at scene.
I understand that, but based on your own knowledge, you didn't know who was driving either car.
Not 100%, not so I take a statement.
Because you didn't see anybody in the driver's seat of either vehicle when you arrived at the scene. Is that correct?
Not when I got there.
That's what I'm asking when you got there. So did you, when you came into the room to interrogate my client, did you advise him of Miranda?
No.
And why is that?
He was not under her arrest.
You were detaining him at that time?
No.
You didn't have enough evidence to arrest him at that time, is that correct?
That's all it was a statement.
I'm sorry.
That's all it was a statement.
Well, I know what your intent was, but you didn't have enough evidence at that time to arrest him for a crime until you took a statement.
True.
And so that's it, Bernard. Again, I would object to the admission of the statement. He's in a hospital bed at the hospital.
That doesn't mean he's under the influence.
Well, we wouldn't know because the officer didn't ask anybody at the hospital, such as a doctor or nurse, as to whether he was.
Sir, you did in fact talk to the defendant,
Yes.
and did he appear to be under the influence to you when you talked to him?
No.
Was he able to follow your questions logically?
Yes.
He gave logical answers to the questions that you asked?
Yes.
He was not in custody at the time?
No.
Just for example, this over.
Objections noted.
I'm gonna zoom in, Your Honor, so I can focus.
While you're getting that set up, let me do this real quick. I'm gonna change gears just one. We're ready on Beverly Jordan.
Calling case number 2405549201 for the state of Michigan versus Beverly Jordan. Defendant is charged with count 1, assault with a dangerous weapon, count 2, domestic violence.
Appearances for the record, please.
Good morning, Jessica Davidoff for the people, PH 6743, standing in for the APA of record, Shelley Draven.
And good morning, Your Honor. Melanie Bates, appearing on behalf of Beverly Jordan. Your Honor, I'm not sure if she's on the Zoom. I don't see her in the Zoom gallery.
Are you waiving her presence for purposes of this hearing?
Yes, Your Honor, I will waive her presence for today's hearing only.
The court will waive the defendant's presence. What's your pleasure?
Your Honor, we'd like to set the preliminary exam.
Continue to plead not guilty and set this matter for a preliminary examination. How is February 28th at she's not in custody, right? How's 9:15?
That's fine. She's not in custody, Your Honor. 9:15 on the 28th?
Yes.
Okay.
All right. We continue. Thank you.
Thank you. Have a good day.
Thank you, Your Honor. I'll see you tomorrow.
Okay. Okay, Mr. Nolan, your call is now.
Thank you. Your Honor, people are playing People's Exhibit 5, starting at 28 seconds. Just to take, play this for about 5 minutes. Your Honor, it's lagging on this court screen, but not on my laptop. If that continues, can I just approach with the laptop?
So my client had a see.
We'll continue to have it playing here.
And I don't hear the audio.
Did you share the audio?
I did.
Are you able to play the audio on your device?
Yes, Your Honor. I'm gonna
I
stop.
should come down there.
Okay. Wait. Oh, his table. Yeah. You can take it.
I'll let you guys listen to it first.
Okay.
Yes, listen to it first. I'll- Yes.
30 seconds to 7 minutes.
You guys see that down there
Your Honor, I'm still zoomed in. That might be messing with the sound. I should zoom out.
Oh, okay. I'll be rid of
What's Zaire's last name? What's Zaire's last name? You know the date of birth? That's what we put Zaire. Yeah. Put the other one.
Can you hear?
We can hear the officer. Can't hear.
22. Yeah. 2018. Yeah. Okay. That's Sarah. Where was Sarah CJ? Front of exit. Was Zaire? I received it from the passengers. That's yes. You guys had it. What's going to do? Or downtown, or downtown. Or downtown. What lane you were in? Right lane, or left lane? Okay. Sure.
In your honor, it's around 7 minutes as we'll start.
Said 7-11.
Yes, I would renew my objection to the admissibility of this.
Why?
Because I believe if Dan presented to the court, you can hear the officers clearly, but you can't hear.
I heard you.
Your honor, the defense counsel had an opportunity to listen to the video. I heard the defendant when I was standing right next to him.
I heard.
Your honor, may I approach?
Yes. Objection overruled.
Detective Basso, Your Honor, may I approach with People's Exhibit 5?
Yes.
Detective Basso, I'm handing you People's Exhibit 5, the video, at 2 minutes and 48 seconds. Detective Basso, who's that individual in the screen right now?
It's like a janitor or something that's clean.
Would that be standard if you're doing an interrogation to have a custodian in there cleaning? During an interrogation?
No.
Your Honor, may I approach?
Yes.
Was the defendant in handcuffs?
No.
What were the two vehicles that were involved in that?
A Chevy Tahoe and a Chevy Malibu.
Okay. Did you obtain CDR reports for these vehicles?
Yes, I did.
And Your Honor, people would move to admit People's Exhibit 3 and 4 for exam purposes only by way of stipulation. of defense counsel.
So stipulated.
No objection for exam purposes.
All right. Proceed.
Your Honor, may I approach?
Yes.
The hand People's Exhibit 3 and 4. Your Honor, may I publish?
Yes.
Starting with Exhibit 4.
Okay.
What is the vehicle make and model?
For Exhibit 4 is the CDR report for the 2007 Chevy Tahoe.
Okay. Was that the defendant's vehicle?
Not the Tahoe.
Okay. Were you able to obtain a speed for this vehicle?
Yes.
Okay. Turning to page 3 of Exhibit 4. About 2.5 seconds before impact, how fast was this vehicle traveling?
16 miles an hour.
Okay. What about 0.05 seconds? How fast was the vehicle traveling?
Same speed, 16 miles per hour.
Okay.
No break.
No break. Okay, looking at Exhibit 3. On the first page, is there a make and model of this vehicle?
For the 2013 Chevy Malibu?
Okay. Is this the defendant's vehicle?
Yes, it is.
Objection is no foundation.
What type of vehicle did the defendant say he was driving?
The Chevy Malibu.
Okay. Was this vehicle removed from the scene on the night in question?
Yes.
Is this CDR report from the vehicle removed from the scene?
Yes.
And were you able to obtain a speed for this report?
Yes.
Turning to page 28, which is tabbed out of everyone's exhibit. Can you tell us the speed 5 seconds before impact?
5 seconds prior to the crash was 69 miles per hour.
And was there break?
No.
What about 3 seconds before impact? How fast was the defendant driving?
70 miles per hour, no break.
What about 1 second before impact? How fast was the defendant driving?
67 miles per hour with the brakes on.
Okay, so again, 3 seconds before impact, how fast is the defendant driving?
70 miles an
And what's the posted speed limit on that road?
hour. 35.
No further questions.
Thank you. Now, Detective, you said that you arrived at the scene of the accident,
Yes.
but when you arrived at the scene of the accident, nobody was inside the Malibu. Is that correct?
That's correct.
So then you went to the hospital. Is that correct?
Yes.
Went to a hospital room
Yes.
where my client was laying, as we saw in the video, under a hospital blanket
Yes.
in somewhat of a fetal position. Is that correct?
Yes.
Your testimony is that my client said that he was the driver of the vehicle,
Yes.
or is that just in response to a question?
think I asked him if he was a driver, and he stated yes.
And you said, is that a yes? We heard that loud.
Yeah, yes.
So obviously he didn't hear his first answer. Well, you just heard it.
Yeah.
And when you asked that question, there was a pause and then you said, is that a yes? Remember that part of the video?
I don't know if he said it like that, but I asked him if he was a driver, and he said.
Now, he also told you that he was driving east on Grand River.
That's correct.
And he also told you, Mr. Robertson, that is, that the Chevy Tahoe turned left in front of him, and he was unable to avoid the Chevy Tahoe.
Yes.
So from the description given to you, pure accident.
I'm gonna object to the legal conclusion in the incident.
The way he described it, he was unable to avoid hitting the Tahoe or that turned in front of
That's his statement.
him. So his statement describes it as an accident.
And I would say that's a legal conclusion to say it's an accident to get it back legal.
He told you he's unable to avoid hitting the Chevy Tahoe because it had fallen in front.
Yes.
No further questions.
You redirect?
Just briefly, Your Honor. Detective Vessel, what does it mean when someone's in the fetal position? Where would their knees be at? They're in the fetal position.
Probably up by their chest.
Okay. Your Honor, may I approach the People's Exhibit 5? I'm showing you People's Exhibit 5 at 2 minutes and 3 seconds.
Sure.
The defendant, where's his legs at when he's lying down? Are they up by his chest?
They're not by his chest, they're at like a 90-degree angle.
Okay. Nothing further.
Thank you, sir. You may have it.
No further questions, or no further witnesses, Your Honor.
Any witnesses on behalf of the
No, Your Honor, thank you.
Your Honor, the people heard first, I'm sorry. Your Honor, people heard from Detective Vessel, who stated he spoke to the defendant, who said he was traveling eastbound on Grand River when someone cut in front of him. Someone was making a left-hand turn, trying to go down the side street, and they cut in front of him. There's no dispute there. Ask the code detective. This crash resulted in Sarah Robinson losing her life. But what's most important is the CDR report. It's 35 miles per hour, and the defendant's traveling highway speed 70 miles per hour, 3 seconds before impact. In addition, he doesn't have a license that was already admitted through the certification. So with that, Your Honor, people are asking that a probable cause standard that reckless driving be found driving 35 miles over the speed. And the added count 4 for driving without a license suspended be added, which is 257-9044.
257.
9044.
Driving my license suspended because of that.
Yes, Your Honor.
Mr. Chris?
Yes, Your Honor. But Judge, we ask you not bind over. I would ask you not assume any facts that are not in evidence. So, in stating that, my client currently is charged as defendant number 1, which is reckless driving causing death. And I noticed that she's moving to add what's listed in the complaint at count 3 against the co-defendant only, but now she's moving to add that as my client also. And then the count of driving my license suspended, legal listed charge. So I address myself to felony charges. The testimony here, as I understand it, is my client is admitted he was driving the vehicle in the statement he made at the hospital. You can consider the circumstances of the hospital in terms of use of the statement against him. He's in a hospital bed, never moves, it's just laying on his side with did admit he was the driver of the vehicle. He said that to the officer, which I interpret as a pure accident, is that he was driving east on Grand River and the Chevy Tahoe turned left in front of him. He's unable to avoid the Chevy Tahoe. So certainly, that's the cause of this accident here, is the Tahoe turning right in front of my client as he's driving the Malibu. I know there's evidence introduced as to the speed, but we don't know what the posted speed limit here is on this area. I don't think you can take judicial notice of that. So that's
You're not submitting that the speed limit would be 70 miles an hour.
No.
Grand River, the city of Detroit.
I'm submitting that if you're going to charge reckless driving, you have to establish. In fact, my client was driving in a reckless manner. There's been no testimony as to what the posted speed is. So I don't.
The officer testified posted speed limit was 35 miles per hour.
I didn't hear that part of the testimony.
No, certainly did. I can play it back for you.
Oh, maybe I missed it. But I don't think that even with that speed, that is reckless driving. Reckless
70
driving.
miles an hour on a 35 mile per hour speed.
Reckless driving, we have to go by legal definitions. Sometimes that overrules anything else. And reckless driving is defined as if someone is driving in wanton and willful disregard for the safety of persons or property. Willful has been defined by case law as conduct that is purposeful or intentional as opposed to accidental. Again, I argue pure accident here in this situation. They have been driving speed that he shouldn't have been, but that's not willful conduct. Wanton disregard means understanding your behavior was risky, but did it anyway. So it's a close call here, but by looking at legal definitions, I don't believe that he was driving in a willful, wanton manner to rise to the level of reckless driving. There's no testimony about him swerving in and out of traffic. There's no testimony about anything as driving other than the speed that he was going. Then a car that is driving at 60 miles an hour pulled right in front of his vehicle, and that's when this accident occurred. So the first legal argument we make to this court is we don't.
You said 60 or 16?
16.
Oh.
And so the first argument we'll make is there's not a showing of reckless driving in this matter, because there's no showing that by the operation of his vehicle, he caused the death of his wife in his own vehicle. And as to suspended license causing death, part of what has to be shown is that he was driving the motor vehicle and he made an admission. His license was suspended, that's been introduced. And then it has to be shown the operation of the vehicle did cause the death. Again, we argue that it was an accident, car pulled in front of him. So in the fact that his license was revoked or he didn't.
And he shouldn't have been driving in the first place?
But he has to show the operation of the vehicle caused the death.
But not for him driving in the residential area, driving 70 miles per hour.
We don't know it's a residential. Or if there's any testimony it was a residential. But he was driving down Gresham. And from Grand River, driving down Grand River. And part of the legal showing is that the operation of the vehicle did cause the death as part of the driving no license revoked. So those are our arguments against my.
Thank you. Thank you. Mr. Mulder? Anything else?
No, Your Honor.
All right, so first and foremost, the defendant should not have been operating the vehicle in the first place, and that his license was suspended. People have charged the defendant with count one reckless driving causing death. I submit to you that driving a vehicle at 70 miles per hour on a street where the speed limit is 35 miles per hour is in fact reckless, in that the defendant in driving that speed is exhibiting wanton and willful disregard for the safety of others. A person is driving and making a left-hand turn, maybe misjudged how fast the defendant was going. They're just going 16 miles per hour, well below the speed. The defendant is literally flying through this area and hit someone and cause the death of that person. Was it the person in the vehicle that he hit that was killed, or was it his passenger?
It was his wife.
His wife. I don't understand why it always turns out that way. The person who's doing this egregious driving never kills himself. He always kills the passenger or someone else. In any event, people are also adding one count of driving on license suspended causing death, but not for the defendant driving the vehicle in the manner in which he was driving, that death wouldn't have occurred in the first place. And Mr. Chris said something about he also moved to add a driving while license suspended. I don't recall you saying that.
No, you're not.
So the court is satisfied that people have met their burden of probable cause as it relates to count one, reckless driving causing death, and added charge of driving while license suspended causing death. The court finding those charges were committed in the city of Detroit, and the court finding probable cause to believe this has been committed will bind within the to Wayne County Third Circuit Court, Criminal Division of Proceedings. His arraignment on the information date and time will be March 7th, 2024 at 9 o'clock a.m. Bound to continue.
Thank you, Hunter.
Thank you.
Yeah.
If they didn't bring them over, well, she probably said they needed to get it back. She said that. So that might have to go with his papers.
There's no normally, I have to six. Okay. Well, folks, that concludes the docket for today. We'll see you tomorrow, same bat station, same bat time. Have a good day.
Right, so you don't need that.
Where is it?
Where? All right.
Thanks, you too. Be safe out there. Later.
Okay.
Have a good one, Jeff.
Okay, guys, have a good day.
Great work with you today.
Don't say I had to give you.
Good job, Terry.
Thank you, man.